Kingdom of Spain and Republic of Zimbabwe against border timbers.
Lord Lloyd-Jones will explain this judgment.
These appeals arise from applications by the Kingdom of Spain and the Republic of Zimbabwe to set aside the registration of arbitration awards in the High Court. In particular, these appeals are concerned with whether Spain and Zimbabwe can rely on state immunity to set aside the registration orders on the basis that they're immune from the adjudicative jurisdiction of the English courts under Section 1 of the State Immunity Act 1978. Sections 2 to 11 of the State Immunity Act establish exceptions to foreign state immunity from the jurisdiction of the English courts. The exceptions relevant in these appeals are Sections 2 and 9. Section 2, subsection 2 provides that a state is not immune regarding proceedings in respect of which it has submitted to the jurisdiction of the courts of the United Kingdom by a prior written agreement. Section 17 of the State Immunity Act explains that an agreement includes international treaties. Section 9 provides that a state is not immune if it has agreed in writing to submit a dispute to arbitration. The issue on these appeals is whether Section 2 and Section 9 apply to exclude the immunity of Spain and Zimbabwe. Spain and Zimbabwe each had an arbitration award made against them pursuant to the 1965 Convention on the Settlement of Investment Disputes between States and Nationals of Other States, also known as the ICSID Convention. The United Kingdom, Spain and Zimbabwe are all signatories to the ICSID Convention. The ICSID Convention provides a framework by which nationals of one contracting state who have invested in another contracting state may, with the state's written consent, resolve disputes arising directly out of that investment through international arbitration. Infrastructure Services Luxembourg, S.A.R.L, and Energia Termosolar B.V., together referred to as infrastructure, are companies domiciled in Luxembourg and in the Netherlands, respectively. Infrastructure claimed that changes made by Spain to its regulatory regime governing its energy market reached the Energy Charter Treaty in respect of their investments in renewable energy facilities in Spain. By an arbitration award, Spain was ordered to pay 112 million euros in compensation, later reduced by 11 million euros. Infrastructure applied to the High Court to register the award against Spain as a final judgment under Section 1 of the Arbitration International Investment Disputes Act 1966. The judge registered the award as if it were a final judgment of the High Court. Spain applied to set aside the registration order on the basis that it was immune from the adjudicative jurisdiction of the English courts under Section 1 of the State Immunity Act. The High Court dismissed the application. The judge held that Spain, by becoming a signatory to the ICSID Convention and the Energy Charter Treaty, had submitted to the jurisdiction of the English courts by prior written agreement under Section 2, subsection 2 of the State Immunity Act. In the alternative, the judge held that there was a valid agreement between infrastructure and Spain for the purposes of Section 9 of the State Immunity Act. Separately, Border Timbers Limited and Hangani Development Co. Private Limited, together referred to as Border Timbers, claimed to have invested in land in Zimbabwe which was later expropriated without compensation. The arbitral tribunal ordered Zimbabwe to pay $124 million plus interest and a further $1 million in moral damages and costs in an arbitration award. This award was registered as if it were a final judgment of the High Court. Zimbabwe applied to set aside the registration order, and the High Court dismissed the application. The judge held that Article 54 of the ICSID Convention constituted a general waiver of immunity by contracting states, but did not meet the elevated threshold of submission to jurisdiction for the purposes of Section 2, subsection 2 of the State Immunity Act. The judge also held that Section 9 of the State Immunity Act required the English court to make its own determination of whether Zimbabwe had agreed to arbitration. In any event, however, the judge held that the registration of an ICSID award is a purely administrative act and therefore not an exercise of adjudicative jurisdiction, such that Section 1 of the State Immunity Act did not apply at all to for the registration of arbitration awards under the 1966 Act. Both Spain and Zimbabwe were granted permission to appeal to the Court of Appeal, and the appeals were heard together. The Court of Appeal held that the registration of an ICSID award under Section 1 of the 1966 Act does engage the adjudicative jurisdiction of the English courts. However, it held that Article 54 of the ICSID Convention is a sufficiently clear and express submission to the jurisdiction to satisfy Section 2, subsection 2 of the State Immunity Act. The Court of Appeal considered it unnecessary to decide whether Section 9 applied, but it indicated that it was difficult to interpret that provision as other than imposing a duty on the English court to satisfy itself that the state in question has in fact agreed in writing to submit the dispute in question to arbitration. The Court of Appeal accordingly dismissed the appeals in a judgment handed down on the 22nd of October 2024. Spain and Zimbabwe appeal that decision to the Supreme Court. The Supreme Court unanimously dismisses the appeals. It holds that Spain and Zimbabwe have submitted to the jurisdiction of the English courts under Section 2, subsection 2 of the State Immunity Act by virtue of Article 54(1) of the ICSID Convention, and consequently they may not rely on state immunity to oppose the registration of the arbitration awards against them. Lord Lloyd Jones and Lady Simler give the judgment with which Lord Briggs, Lord Sales and Lord Leggett agree. There are two questions arising in respect of Section 2, subsection 2. The first is, what is the test for deciding whether there has been a prior written agreement to submit to the jurisdiction under Section 2, subsection 2 of the State Immunity Act? This is a matter of domestic law. The Supreme Court holds that a waiver of immunity by treaty requires a clear and unequivocal expression of the state's consent to the exercise of jurisdiction. An expression of consent does not require explicit words such as waiver or submission. The test for considering a waiver of state immunity by treaty is whether the words used necessarily lead to the conclusion that the state has submitted to the jurisdiction. The second question concerns the correct interpretation of Articles 53 to 55 of the ICSID Convention as a matter of international law, and whether Article 54, paragraph 1, meets the test under Section 2, subsection 2 of the State Immunity Act. This depends upon an exercise of treaty interpretation based on the principles found in Articles 31 and 32 of the Vienna Convention on the Law of Treaties 1969. Article 54, paragraph 1 provides that each contracting state shall recognize an award as binding and enforce the award within its territories as if it were a final judgment of a court in that state. The ordinary meaning of Article 54(1) is that each contracting state consents to awards to which it is a party, being recognized and enforced in other contracting states. In other words, Spain and Zimbabwe have consented to the arbitration awards against them being recognized and enforced in the English courts. The mutual and reciprocal obligations under Article 54(1) are inconsistent with the preservation of immunity from adjudicative jurisdiction. This conclusion is apparent from the express words of Article 54(1) and does not involve the implication of terms into the ICSID Convention. The scheme of Articles 54 to 55 of the ICSID Convention draws a sharp distinction between recognition and enforcement on the one hand and execution on the other. It is significant that only immunity from execution is expressly preserved in Article 55. Further, there is no basis for limiting the application of Article 54 to the recognition and enforcement of awards against private investors. On the face of it, Article 54 applies to awards against both private investors and contracting states. The treaty context reinforces the conclusion that Article 54 is a waiver of immunity from adjudicative jurisdiction. Article 54 is part of a self-contained scheme intended to result in binding and enforceable awards which a national court may not re-examine. The object and purpose of the ICSID Convention also supports this interpretation. A primary purpose of the Convention is to encourage the flow of private investment and provide protection against sovereign risk. We reject the submission that an agreement to exercise jurisdiction can only be a waiver of immunity if otherwise the object and purpose of the treaty would be entirely defeated. In the instant case, the preservation of adjudicative immunity would render valueless the protection afforded by Article 54(1) in making enforceable the pecuniary award as if it were a final judgment of a court in a contracting state. The travaux préparatoires or preparatory works of the ICSID Convention further confirm the meaning of Article 54(1). Finally, the principle of consistent interpretation provides that international treaties should be interpreted consistently by national courts. The judgment refers to the broad international consensus in the courts of Australia, New Zealand, Malaysia, and the United States that Article 54(1) is a waiver of adjudicative immunity by each contracting state. In the light of the conclusion reached on Section 2, subsection 2, it is not necessary to determine whether Spain and Zimbabwe agreed to arbitration for the purposes of Section 9, subsection 1 of the State Immunity Act. For these reasons, the appeals are dismissed.
The court is now adjourned.